Welcome to this explainer. Today, we're diving straight into the vital and honestly pretty complex relationship between Indigenous peoples and the Canadian state. Our goal is to make sure you are completely prepped for your exam. Now, this is a foundational topic, and it's deeply rooted in Section 9124 of the 1867 Constitution Act, which originally assigned federal authority over what it called Indians, and then the massive legal shift that happened a century later in 1982. Let's build your understanding of this step by step.
All right, here's our game plan for today. We'll start with the constitutional foundation, move on to proving Aboriginal rights, tackle the Aboriginal title test, explore treaties and reconciliation, break down the duty to consult, and wrap up with a final exam review summary. Part 1, the constitutional foundation. Okay. We have to start with the honor of the crown. This principle literally colors absolutely every other legal test we're going to talk about today. Listen, it is not just some polite, flowery phrase. It's a strict constitutional obligation. Because the crown assumed sovereignty over these lands, it operates under what's called a fiduciary duty. Basically, that means the state is legally required to act with the utmost good faith, fairness, and integrity in the best interest of Indigenous communities. And this brings us to the ultimate constitutional anchor. Section 35(1) of the Constitution Act of 1982 explicitly states that these rights are recognized and affirmed. To put that into perspective, prior to 1982, these rights could just be extinguished by a simple, unilateral piece of government legislation. But after 1982, no way. That is no longer possible. They are permanently guaranteed and protected from simple legislative override. Moving on to Part 2, proving Aboriginal rights. So if there's one thing you absolutely must memorize for your exams, it's the Peet test. This is the legal checklist used to define an Aboriginal right. Say an Indigenous group claims a right to, fish in a specific area. The court goes right to this test. The activity has to be an integral practice, custom, or tradition, meaning it's of central significance to their distinctive culture, not just something incidental. And crucially, it must have developed prior to European contact. If the practice has evolved into a more modern form today, the group actually has to be able to trace its origins all the way back to those pre-contact days. But, there's a pretty major critique of the Peet test, and it's the risk of freezing rights in the past. Think about it. Cultures are living, breathing things, right? A super strict, static interpretation of pre-contact practices kind of traps Aboriginal rights in a historical museum, rather than allowing them to naturally adapt to modern-day circumstances. All right, Section 3, the Aboriginal title test. So, proving a right to do a specific activity is one thing, but proving Aboriginal title, which is the right to the land itself, that is a massive hurdle. Enter the Tsilhqot'in Nation case. This gave us a critical 3-step framework, and yes, this is prime exam material. First up is sufficient occupation, meaning a strong presence that clearly communicates ownership to third parties. Second is continuity. The present occupation has to trace back to pre-sovereignty times. And third is exclusivity, meaning they had the intention and capacity to retain exclusive control of the land at the time of European sovereignty. Now, it's super important to understand that Aboriginal title is not your standard everyday real estate. It's a collective generational right. Legally, we call it sui generis, which just means it's totally unique, one of a kind. Unlike traditional fee simple ownership, where you can just flip your house and sell it to whoever you want, Aboriginal title is communal. It can only be transferred to the Crown. And maybe the most fascinating part, the land inherently cannot be developed in a way that deprives future generations of its benefit. Which brings us to Section 4, treaties and reconciliation. Let's talk about the solemn promises made between the Crown and Indigenous peoples. When courts look at a historic treaty from, say, the 1800s, they do not apply strict, rigid contract law. Instead, they look at the cultural differences and historical realities of that time, requiring a generous contextual interpretation to make sure the honor of the Crown is upheld. Modern treaties, mostly post-1973, are a bit different. They're comprehensive land claims meant to define rights explicitly for today. But honestly, regardless of the era, both always have to be interpreted with one ultimate goal in mind, furthering the ongoing process of reconciliation. And today, we are seeing a massive contemporary shift. Treaty rights are increasingly being interpreted to conciliate two sovereign nations, strongly guided by the Truth and Reconciliation Commission, or TRC, and the modern lens of UNDRIP, the UN Declaration on the Rights of Indigenous Peoples. UNDRIP places a really heavy emphasis on the presumption of conformity. This means Canadian courts are actively trying to align their interpretation of Section 35 rights with international standards, formally recognizing this ongoing, living relationship. Let's jump into Section 5, the duty to consult. Let's pause for a second. Here's a fundamental exam question you need to know. When exactly must the state actually consult Indigenous communities? While the rule is pretty clear, the duty is triggered when the Crown has real or constructive knowledge of a potential or actual Aboriginal right or title, and they are contemplating conduct that might adversely affect it. Whether they're building a new pipeline, approving a massive mine, or testing offshore waters. If it impacts those rights, the Crown absolutely must consult, and if appropriate, accommodate. To really get a grip on this, let's look at two contrasting cases that show us the exact legal limits. In the Chippewas of the Thames case, the duty was triggered and the National Energy Board stepped up perfectly. They gave early notice, provided funding so the community could hire experts, and held oral hearings to listen to concerns. The court said, yep, the duty was met. Contrast that with the Clyde River case. There, the Inuit faced a project that risked their treaty rights to hunt marine mammals. Yet they were given zero funding, no oral hearings, and thousands of pages of deeply inaccessible scientific documents. The Supreme Court decisively ruled the duty was breached and entirely quashed the project. Now, one really critical takeaway from that Chippewas case is this idea of delegation. The government can rely on a regulatory tribunal like the NEB to fulfill its duty to consult, as long as the process is robust. But, and definitely write this down, the ultimate constitutional responsibility, that always rests with the Crown. It literally cannot be delegated away to a board. If the regulatory body drops the ball and fails to consult adequately, the Crown has to step in. Finally, Section 6, our final exam review summary. All right, let's tie all these concepts together. What happens if a protected right is actually infringed upon? Well, the burden shifts straight to the government. They have to justify that infringement using the principles from the Sparrow test. First, an Indigenous group has to prove a prima facie infringement, meaning the government imposed undue hardship, acted unreasonably, or stopped them from exercising that right. If they prove that, the government then has to justify it by showing they had a valid legislative objective, like natural resource conservation, and prove they upheld the honor of the Crown by infringing as little as possible, offering fair compensation, and actually consulting the group. And building right off Sparrow, we have this three-step test from Tilkyathan that determines if an infringement on Aboriginal title specifically is legally justified. Step 1, did the government properly discharge its procedural duty to consult and accommodate? Step 2, is the action backed by a compelling and substantial public objective? And Step 3, is the action substantively consistent with the Crown's fiduciary duty to that specific Indigenous group, keeping in mind that the land is held for future generations? If the government fails even one of these steps, the infringement is unconstitutional. As we wrap up this explainer, I want to leave you with a final thought. As Canada continues to pursue aggressive natural resource development and major climate initiatives, how will the honor of the Crown survive when those massive economic interests inevitably clash with absolute generational Aboriginal title? It's not just historical theory. It is literally the most high-stakes legal balancing act in the country today. Master these constitutional frameworks, and I promise you're going to ace your exam. Thanks so much for joining me for this explainer.